removal order options you probably don't know about. Rafael had a removal order from a case he did not even know went to a hearing. He found out when I showed up at his door. He had been in the United States for 19 years. He had 3 kids who were born here. He was convinced his situation was hopeless. But a removal order is not always the end of the road, and Rafael's story is not unusual. Thousands of people have orders they received without proper legal representation or orders they did not know could be challenged. I'm Kate Lincoln-Goldfinch, an Austin immigration attorney, and I'm going to walk you through every option that might still be available to you. If you have a removal order, you are in a serious situation. I am not going to sugarcoat that. But serious does not mean hopeless, and it definitely does not mean you have no choices. What it means is that time matters, and every option you have depends on your specific facts. Let me walk you through what those options actually are, because the number of people who have an order and assume there's nothing left to do is significant. And for many of them, that assumption is simply wrong. First, understand what kind of order you have. Not all removal orders are the same. There are final orders of removal issued after a full hearing in immigration court. There are in absentia orders, which are issued when someone did not show up to their hearing. There are expedited removal orders for people arrested near the border or shortly after entry. Each type has different rules about what you can do next. The first step is getting your full immigration file so you know exactly what you are working with. If you do not have your file, an attorney can request it for you. A motion to reopen asks the immigration court or the Board of Immigration Appeals to reopen your case so that new facts can be presented. This is one of the most powerful tools available, and a lot of people do not know it exists. You might qualify to file this motion if you never received proper notice of your hearing date, if something significant has changed in your life since the order was issued, or if your prior attorney made serious legal errors that affected the outcome of your case. That last ground is called ineffective assistance of counsel, and it is more common than people realize. Immigration attorneys have made mistakes that resulted in removal orders that courts have since agreed were improper. The rules around motions to reopen are strict, and there are filing deadlines. But courts do make exceptions in cases involving fraud by a prior attorney, genuine lack of notice, or circumstances that were genuinely impossible to foresee. If you received an order and you did not fully understand what was happening, or if you did not have an attorney at all, that motion deserves a serious look. Motion to reconsider. This is different from reopening. A motion to reconsider asks the same court to look at the same record again and find a legal or factual error in the original decision. You are not adding new evidence. You are arguing that the judge applied the law incorrectly or relied on a factual finding that was not supported by the record. This requires a strong grasp of immigration law and a specific, well-supported argument. It is not a let's try again motion. But when there is a genuine legal error, it is a real avenue. BIA appeal. If you just received a removal order and you are still within the appeal window, which is generally 30 days from the date of the order, you may be able to appeal to the Board of Immigration Appeals. The BIA reviews immigration court decisions for legal error. This is not a retry of the facts of your case. It is a legal argument about whether the immigration judge applied the law correctly. If the BIA rules against you, there is the possibility of further appeal to the federal circuit courts, which is a longer and more complex process, but one that has produced significant results in many cases. A lot of people who receive removal orders without an attorney did not know they could appeal. The immigration judge may have explained the appeal right at the end of the hearing, but in a moment of shock and fear, most people do not absorb that information. If your 30 or 10 days has not run out, you may still be able to file. If it has, that is a different but still important conversation because there are circumstances in which late filing may be addressed through other motions. The key thing is to find out where you stand immediately, not in 2 weeks. Timing on this is critical. 30 days sounds like a lot. When you're scared and trying to understand what just happened, it is not. If you have received a removal order, the first call you should make should be to an immigration attorney. Cancellation of removal. This is a form of relief that allows certain people to have their removal stopped if they meet specific requirements. For lawful permanent residents, green card holders, there's one set of criteria, including years of residency and good moral character. For people who are not permanent residents, there's a separate category that requires 10 years of physical presence in the United States, good moral character during that time, and showing that your removal would cause exceptional and extremely unusual hardship to a qualifying U.S. citizen or permanent resident, spouse, parent, or child. The hardship standard is genuinely high. But when it applies, the result is that you are allowed to remain in the country. It is worth evaluating if you have been here a long time and have qualifying family members. Asylum and protection-based claims. If conditions in your home country have changed since your original immigration case, you may be able to raise new asylum or protection claims even if prior claims were denied. Courts can consider changed country conditions as a basis for reopening. This is one of the reasons why situations in Venezuela, Cuba, Honduras, El Salvador, and other countries with deteriorating conditions have created new legal arguments for people who were ordered removed years ago when circumstances were different. A changed conditions motion to reopen is a distinct legal tool that an attorney can evaluate if your country's situation has worsened. There is also a category of protection that is separate from asylum entirely. If you or someone you know would face torture upon return, there is a separate legal protection available regardless of past immigration history, criminal history, or whether prior asylum claims were denied. This protection applies in a narrower set of cases, but it has no time bar. An attorney can evaluate whether it applies to your situation, even if everything else seems closed. Voluntary departure, what it actually means. Sometimes people hear voluntary departure and assume it is the same thing as being deported. It is not, and that difference can matter significantly for your future. Voluntary departure means you agree to leave the country on your own, at your own expense, within a court-set timeframe. In exchange, you do not have a formal removal order on your record in the same way. That matters because formal removal orders can trigger bars on returning to the United States legally, sometimes for 10 years or permanently, depending on the circumstances. Voluntary departure, if you qualify for it, can preserve legal options that a removal order would close. It is not a good option for everyone. For some people, it is the most strategic path available. Prosecutorial discretion. This is the least certain option right now, and under the current administration, it is harder to rely on than it was a few years ago. Prosecutorial discretion means that immigration enforcement has the authority to deprioritize certain cases based on humanitarian factors, community ties, length of residence, and other considerations. It does not provide legal status and it can be reversed. But in some cases, administrative closure of a case while pursuing other relief is a meaningful step that buys time and keeps other options open. Stay of removal. If you are facing imminent removal, you can ask the court to issue a stay, which temporarily suspends the removal order while your case is being reviewed. This usually requires filing an appeal or a motion at the same time. It is not automatically granted. But in cases where there are serious legal arguments to be made, a stay can provide enough time for the legal process to work. In some cases, those extra few weeks or months are the difference between a family staying together and a family being separated. A stay can also be sought at the federal court level in some situations. When an appeal is filed in a federal circuit court, the court can be asked to stop removal pending the outcome. There are families who have been able to remain in the United States for years while federal appeals work their way through the courts. I'm not telling you that this is the likely outcome in every case, but I am telling you that the process is layered and there are more stops along the way than most people realize when they first hear the word removal. The in absentia order, a special note. If you have an in absentia order, meaning you were ordered removed because you did not appear at a hearing, I want to speak to you directly. These orders happen for reasons that are often not the person's fault. The notice went to an old address after a move. The attorney did not communicate the hearing date. Someone misunderstood what was required. Courts have reopened these orders when the person can show that they did not receive proper notice and that they have a viable defense to present. If you have an in absentia order, that specific question deserves serious evaluation before you assume the order is unbeatable. It may be the strongest argument you have. The bottom line. Rafael ended up qualifying for a motion to reopen based on not having been properly notified of his hearing. His case was reopened. He got a new hearing. He is still in the United States with his family. I am not promising that result for you because every case is different. What I am telling you is that the number of people who had removal orders and found options they did not know existed is real. The mistake is not calling an attorney because you have already decided the answer. If you want to understand your rights before something like this happens, watch my video on what to do when ICE comes to your door. The link is right here. If you have a removal order and you're not sure what your options are, talk to an immigration attorney soon. Time limits on these filings are real. At Lincoln-Goldfinch Law, we evaluate cases like this every day. Visit lincolngoldfinch.com. Subscribe so you do not miss the next video.